Good afternoon, everyone, and welcome to the state and local webinar. I am Elizabeth Newmoff from the Office of Intergovernmental Affairs. IGA, as we call it, is the liaison to the state and the local governments, and we want to encourage you all to keep in touch with us. And if you need to reach us during this webinar or anytime other than this webinar, please feel free to email us. The email address is iga@fcc.gov. So again, that's iga@fcc.gov. And I also just want to let folks know that we have just recently realized that we had a problem with the email account, and it was not receiving all email messages. It is now working, so you should be able to reach us that way. Please feel free to email us during this event if you have questions. Again, that email address is iga@fcc.gov. The email account will also be posted on the bottom of all the slides as we're talking. So you should be able to see that if that's helpful for you. And with that, I think we'll turn our presentation over to our speaker today. David Saratsky is here from the Wireless Telecommunications Bureau, and he's going to talk to us today about wireless broadband infrastructure deployment.
Thank you, Elizabeth. I'm happy to be here with you, and I'm going to talk about the Notice of Proposed Rulemaking and the Notice of Inquiry that the Commission voted to adopt in April, this past April. Here's an overview of the conversation. I'm going to explain why the FCC has undertaken this action, or some of the issues that we are looking at that are giving the FCC the thought that we need to take action. Then I'll talk a little bit about the background, how we got to where we are now, both the statute as well as past FCC actions, and then some pending matters that are related to what we're talking about today. Then the main focus will be on the Notice of Proposed Rulemaking and Notice of Inquiry, and I will use the acronyms NPRM and NOI, so now you know what they mean. You probably already did. I'll touch on the process for filing comments and reply comments, and to preview, we really would like to get your comments and reply comments, so please do file. Our system is electronic, and one thing you should be aware of is even after the closing of the reply comment period, there are opportunities to file comments or letters or meet with us under the permit but disclose process, which means you are permitted to make presentations, but they have to be disclosed through our electronic comment filing system. And we'll talk about that a little bit. And most importantly, we're going to have time for questions and answers. And to echo what Elizabeth told you, at the bottom of the screen, there is an email address, and we're not going to be using the WebEx chat box. We are going to be using email, and we are going to be monitoring this email address in real time. So hopefully we'll have a good conversation. And we have a printer right here in the room. We'll be printing out the emails, and Elizabeth will be able to read them, and I'll be able to answer them, I hope. So with that, we'll get into the conversation. Why is the FCC taking this action? Why are we launching these proceedings? Just to focus on consumers, it's really mostly primarily about getting service to consumers. That is the mission of our agency. And everybody listening to this call probably has a phone in their pocket. A lot of us have tablets or other devices that are connected using wireless service. We are looking at wireless data consumption growing six-fold over the next 5 years. So that's not just the increase in smartphone subscriptions. There are a lot of other things that consumers are using or will be using to get to the wireless internet. And these are going to take a lot of data. And of course, the need for meeting that demand is what drives the need for network capacity. And that includes physical infrastructure. So there's a lot of talk about 5G, 5G is the upcoming broadband technology that is just being rolled out now, and it's going to enable a lot of new services, higher speed, greater capacity. It's going to work better than the existing network services, and it will require new kinds of networks, lower power, other kinds of changes to the technology. We are looking forward to the Internet of Things. We're actually living in the world of the Internet of Things already, and we're going to have a lot more of them. We've all heard about the self-driving cars, the smart grid, mobile healthcare monitoring devices, sensors, you name it. There's going to be more and more of it. We're thinking we're probably going to see, what is this, a fourfold increase over the next 5 years. So the Internet of Things is also driving demand for greater capacity, lower latency, and so on. So the problem that we are looking to solve, more infrastructure is needed to satisfy all this growing demand. We need to get more spectrum out that can be used for it, and the Commission is working on that. And we also need to be sure that there are enough antennas and towers and base stations and so on to serve all of these new services and new technologies and new demands. One way, and of course the FCC doesn't build these things, the carriers and the tower companies do. One way that they're doing that is using what are called small cells and distributed antenna systems, and these are low-powered systems. They function in the same way as cells in ordinary cells, but the antennas are a lot smaller, and the towers are shorter, and you need more of them. They're very good at filling gaps or increasing the quality of data transmission. Here are a couple of pictures of small cells. As you can see, they're often mounted on existing infrastructure. Here it looks like it's a street light with a small cell here, and this looks like a utility pole. And sometimes you have more and sometimes less equipment. So typically 1 or 2 small antennas per site. There is other equipment that might be on the pole or on the ground. You might see it on a building, you might see it on a traffic signal, utility poles, etc. They are smaller, they are less obtrusive than a traditional macro cell tower, and that means that they're less costly, they're also more efficient. But it means that you have more of them. People use this word densification. You have to densify them. If I were their English teacher, I would have never allowed them to use that word, but I was not. So here we are. Here are a few more pictures. This looks like a new pole. There's equipment on the pole, small cells over here. This looks like an existing utility pole. There's a little bitty antenna on top that you can barely see. Obviously, it looks like this pole was here in the neighborhood before the small cell came along. Here are a few more examples. This just gives you a taste of the idea of where they might be deployed. They can be used in rural areas as well as suburban and urban areas. So it's really an exciting new kind of technology. And of course, if you compare it to the traditional macro cells, it's a lot more bothersome to have one of these guys in your backyard than something like this. So this is going to be helpful for consumers to get better technology, better coverage, better capacity, better service, while avoiding having this guy sitting on top of their CVS pharmacy, which may be a little less appealing. So how does this get us to the proceeding that we are looking at now? There are challenges that are facing state and local governments and challenges facing the industry. And our hope is that we can address these challenges. Of course, for the cities and the counties and the states, you have a lot more cells coming in, and that means more applications, more zoning, more processing, and that creates a strain on the process. One of the things that the FCC wants to do is to respect that process, maintain the integrity of the process, but also help speed things up. The service providers tell us that it takes too long and it's too difficult sometimes, in some places, to obtain site approval. In other places, we're hearing that things are going along swimmingly. So, but where it's taking a long time, it may get in the way of deploying this infrastructure, and it also increases costs. And the more money people are spending on lawyering to get those approvals from the local jurisdictions, the less money they have to actually put up the facilities, and that doesn't really benefit anyone. So we want to go forward with making this go better for everybody, and we're operating under the framework of the Communications Act of 1934, which was overhauled in 1996. And the Telecommunications Act of 1996, Congress directed the FCC to preempt state and local laws or practices that prohibit or have the effect of prohibiting the provision of service, including wireless, preemption of practices that unreasonably discriminate against providers of functionally similar services. But it's also very, very clear that it preserves state and local governments' authority over decisions about the placement, construction, and modification of wireless facilities. And that is Section 332C7A of the statute. Now, that authority is not unlimited. It does, the statute does impose limits, and it says, among many other things, if you're going to reject an application, that rejection has to be in writing. You have to explain why. You can't have a state or local government look at RF emissions. That is an exclusive FCC area of concern. And for purposes of the conversation we're having today, the most critical limitation is that you have to act within a reasonable period of time. And if a state or local government has an application before it for a long, long time, a litigant, I should say an applicant, can become a litigant. They can bring a suit. They can bring a suit if you reject their application, and they can also bring a suit if you fail to act within a reasonable time. So what the heck is a reasonable amount of time? This question was brought to the FCC just shy of a decade ago, and the FCC put out what's called the shot clock order in 2009. And the question here is, when can the applicant sue? When is the trigger point for failure to act? And the FCC answered that question and said, well, 90 days ought to be a reasonable period of time for co-location applications. For any other kind of application, 150 days is a reasonable amount of time. And if you fail to act within that time frame, that's when the applicant has an opportunity to bring it to court. So that's the regulatory background going back to 2009. And I should say that this 2009 order was upheld by the Fifth Circuit and affirmed by the U.S. Supreme Court. They agreed that the FCC has authority to make these decisions, and the decisions that we made were reasonably within the what the statute permits us to do. In 2012, Congress came back and said, we're still seeing some problems, so let's focus now on proposals that shouldn't take any time to approve because they don't have any substantial change to the physical dimensions of the structure. We're just talking about co-location of either new transmission equipment or swapping out existing equipment on an existing structure. And for those kinds of deployments, Congress said state and local governments may not deny and shall approve those applications. So that significantly limits the discretion of the zoning authorities, but it's the kind of thing that would be hard to explain why you might deny something like that. And the FCC came along and explained in 2014 that 60 days ought to be a reasonable period of time for this kind of application, and that failure to act within that reasonable period of time doesn't just trigger the opportunity to file a lawsuit, it means that the application is deemed granted. So that really should be the end of the story. I'm going to show you these links, and you can have your lawyers look them up and read these orders later on. And if you are a lawyer, you've probably already read them. So the notice that we're talking about today is one that was issued in April 2017, but there's some pending proceedings that are closely related, so I just want to touch on those real quickly. The Wireless Bureau put out a public notice in December of 2016, partly seeking comment on a petition for declaratory ruling filed by a company called Mobility, and asking a few questions that go beyond the scope of that petition. So that petition focused on fair and reasonable compensation for use of public rights of way. So there are a number of questions in that petition that focus on that: cost base, percentage of gross revenues, discrimination, whether to change the shot clock deadlines for small cells, whether we should have a different process if they're submitted in a batch. Does that mean that it should take longer or less time? So a lot of interesting and important questions in that public notice, and the comment and reply comment periods have already completed, and the Commission is looking at that record. There's also an advisory committee, and many of you are probably participating in it or following it closely. This Broadband Deployment Advisory Committee, or BDAC, was formed in January of this year. The members were appointed back in March or April. There are representatives of state governments, local governments, all different sectors of the industry, and there are also 5 working groups which have more participants who aren't even on the committee, and there are 5 different working groups addressing these 5 topics that are on the slide. 2 of them may be of particular interest. There's one looking at a model municipal ordinance to facilitate deployment. That would cover issues like zoning, permitting. There's another one looking at model state statutes. There is one that is looking at federal agencies, land management agencies and so on, that have authority to grant or deny these requests and how to get them to speed up the process. So this BDAC is a very important and very wide-ranging process, and we're excited about the issues that they're going to be looking at and helping the FCC make decisions on. And here are some links and citations for those. And the bottom item on this list is what we're going to focus on, which is the notice of proposed rulemaking and notice of inquiry. That's a single document. It was issued, it was adopted by the Commission and released in April of this year. And there are really 2 separate areas of interest that are focused on. One is how to expedite the state and local government siting review process, and the other is looking at our environmental and historic preservation decision-making process. And they're both extremely important, but for today we're going to focus on the state and local government review.
Can I stop you for just a second?
Please.
We're getting some questions on where the links will be available and whether the slide presentation will be available. So we'll put that on the IGA webpage later today, or at least as soon as we can get the web team to get it up there. But and the archived version of this will also be available once we can get the captioning incorporated and all of that. So it'll be available to watch, listen to, and we'll try and get the links put up too for you to use.
Right. And this is also going to be entered into the record of the proceeding in the ECFS, Electronic Comment Filing System. So, but this This slide deck is going to be up there, so you'll have an opportunity to come back to that. So as I said, there are two categories of issues in this notice. One is about state and local. The other is about environmental and historic preservation. The state and local section has three sets of proposals. One focuses on the shot clock deadlines, which I mentioned before. Second is to expand the scope of the deemed granted remedy for cases where a land use authority misses the deadline. And then it looks into the issue of moratoria, and I'll touch on each of these three. The shot clock. The notice asks about whether the shot clock requirements should be changed. And of course, there are questions about whether perhaps there should be shorter deadlines for certain categories of siting requests. So for example, we have this very narrow category of co-location requests that was addressed in the 2012 statute, and perhaps there are other types of requests beyond what's in that statute. Maybe there are other things that should take a shorter amount of time, 60 days instead of 90 days. Different proposals will be looked at. We're also looking at whether we should change the deadlines based on other kinds of factors. Perhaps the deadline should be longer for a really tall tower and shorter for a short tower. Maybe it should depend on the size of the equipment. Maybe it should depend on how the area is zoned, or maybe rural versus urban or suburban should have different rules. So there are a lot of different ways that we could slice this, and we are welcoming proposals on that. We are also looking at the deemed granted remedy, and the item proposes to apply the deemed granted remedy beyond what's already been adopted for the Spectrum Act applications. So perhaps instead of just triggering litigation, the deemed granted remedy should apply more generally to all applications or to some subset of applications. The notice offers a couple of different legal and policy ways that this could work. One way is to change the rules in litigation. So because the application is deemed granted, if you get into a lawsuit, hopefully you don't, the court would assume that it was granted unless, unless there's some evidence that the jurisdiction actually did act on time. But you couldn't argue that there's justification for the delay because, we would say these shot clocks are the law. Another way to do it is just to say your authority is preserved to grant or deny these zoning applications, provided that you act by the applicable deadline. And if you don't, then perhaps that kind of approval is no longer needed. So these are all options and different ways that the Commission could look into this deemed granted remedy, but a lot of sub-options to the options are still under review. Moratoria. We have heard that some local governments are saying, we don't know how to process these, we want to put them all on hold until we figured it out. You can't do that. The existing 90-day and 150-day shot clock deadlines still run, regardless of whether you're trying to figure out what to do. But even though that's pretty clearly spelled out in past decisions, we're still hearing about restrictions on filing or processing applications, and we'd like to know more about this. If that is happening, what should we do? Is there a need for using our preemption authority? These are all questions that are raised in the NPRM. Turning from the notice of proposed rulemaking to the notice of inquiry. Typically, when you're dealing with an NOI, the proposals are less specific and the issues are a little bit more high level and broad. So we're looking, for example, again, for the lawyers, there are two statutory provisions. They both talk about prohibiting or have the effect of prohibiting the ability to provide service, but the contexts are different and a lot about these statutes are related but somewhat different. So we're looking at those and they have a real world impact. For example, how do they affect pricing of the use of public property other than the rights of way? We already have a pending proceeding that I mentioned before, which is looking at fees for rights of way. So this notice of inquiry asks about other types of publicly controlled property. When a state or local government provides access to resources, is that a proprietary or a regulatory action? Are they acting as the owners of this, for example, right of way, or are they regulating it? And those have important implications for the application of federal law. We're also looking into questions about aesthetic considerations. Of course, the zoning process looks into aesthetics, but there's a limit. And what is that limit? Different courts have come out in different ways. Maybe there are some legitimate bases, but maybe there are some that aren't. Like if you just have generalized, we don't like cell towers, they're ugly, maybe that's beyond the pale. So we have to look into that. We're also looking into discrimination. For example, if you say all utility facilities, all communications facilities must be underground, well, that's good, but how are you going to get wireless service from an antenna that's underground? That's a question, and we don't know what the answer is, but we're asking the question and we're looking for your comments. So this just refers to the environmental and historic preservation issues. We're not going to spend too much time talking about them, but we're looking into streamlining those review processes, which are mostly happening at the FCC level. We're also looking at the function of the review by the tribal nations, fees and so on. Then there's a separate proceeding involving wireline or landline infrastructure. In every area, the Commission's very focused on promoting the rapid deployment of broadband infrastructure. And in the wireless area, we're talking about antennas and we're talking about small cells and 5G and so on. In the wireline area, they're looking at fiber cable. And so there are a lot of questions there about how do we make it easier to get the fiber out there. Both proceedings are looking at issues like whether there should be preemption of state or local laws that inhibit broadband deployment. So that's an area that is raised in both of these proceedings in somewhat different ways. So the comments are due on June 9th, which is coming up awfully soon. There's a reply comment deadline of July 10th. And as I mentioned before, the record does not close at those deadlines. We would like to have a good, solid record based on the comments, but you'll also have opportunities to file ex partes or to come in and meet with us, meet with the commissioners or other people at the agency. And as I mentioned before, those are subject to permit but disclose rules. And you go to this website, ECFS, Electronic Comment Filing System. You can very easily upload your document and just put in the docket number and your organization's name, and presto, no red covers or blue covers or green covers like some of the appellate courts use. You just submit that PDF. And so we are very much encouraging people to file, and we are looking forward to reading comments. We know there will be quite a few. There's an email address and a phone number for any assistance you might need with using ECFS. And here is my email address and phone number. Don't ask me about ECFS, but certainly you can feel free to talk to me about the have your questions answered. But for the time being, we have this email address at the bottom of the page, iga@fcc.gov. And we have a few questions here already that I'm going to take. And if you have more, shoot them in, and we'll try to take as many as we can.
Can you talk a little bit about, because some of the people who are on the webinar today are not lawyers. So we talk about NPRM, which is a notice of proposed rulemaking. and an NOI, a notice of inquiry. And can you talk a little bit about how the April NPRM/NOI plays in with the what we're calling the BDAC, or the Broadband Deployment Advisory Committee, and whether the timing of one affects the other, whether they're waiting from one to the other?
Sure. Those are good questions. Any agency has to issue one of these notices before it can adopt an order, and that's pursuant to the Administrative Procedure Act, which is really about due process of law. So we don't make decisions without asking people who are going to be affected by those decisions, and that's why we have this public process. At the same time, we have now this advisory committee that is looking into a lot of related issues, and we don't know whether one is going to pop before the other or the other before the first, partly because we haven't yet seen the comments. We don't know what people think. The BDAC is just getting off the ground, but we don't want to foreclose any action either way. We do see that there is time sensitivity and urgency to getting this deployment going, to meeting consumers' needs. So both of these processes are going forward simultaneously, and we will see how things play out. And there's no reason to think that one will happen before the other or the other before the one. We're still in a learning mode, so we'll see what we find out.
And then similarly, with regard to the NPRM/NOI from April and the mobility public notice, can you talk about how they interplay and how the timing of both of those works out?
Sure. As I mentioned, there are some issues that are closely related in the two documents, and there are also some issues that are different. The public notice asks a lot of detailed questions about fees for the use of rights of way. The notice of inquiry in the April item looks into fees for other kinds of publicly controlled resources. And of course, the NPRM is much broader, and it talks about a lot of specific proposals, such as the deemed granted and the change in the shot clocks and so on. So it is a lot more focused. But we're looking at both of these sets of proposals and questions and issues. And to the extent that you've submitted information in the public notice docket, the 2016 public notice, and you want to get it in front of us in the 2017 docket, just to make things neat and clean, it'd be useful if you could just submit the information into the second docket, and we will be looking at all of it. And of course they're related, and we understand that, and we're going to be looking at them in tandem.
Sorry, we're trying to understand some of the questions. If you've asked a question and used an acronym, could you please send us in you spell out the acronym for us so we know for sure what you're referring to? Then one of the other questions that we have is the relationship between the NPRM NOI and wire, which is the one we're talking about today, is about wireless broadband deployment. And then there was a similarly timed NPRM/NOI on wireline broadband deployment. And can you talk about kind of the relationship of those and how that plays out?
Sure. Both of them, in the notice of inquiry section of those two documents, there are questions about preemption. So what does it mean if a state or local requirement has the effect of prohibiting someone's ability to provide service? And it's the same statutes, or at least the section 253 is the same. So both of the notices ask questions about that. And of course, the bureaus here talk to each other and the commissioners talk to each other. So we will be looking at all those proposals. But of course, there are a lot of issues that are very separate on the wireline side with the fiber deployment and on the wireless side. And so those will be looked at. And again, hard to say, really impossible to say at this point what the timing is going to be, because we still don't even have the records yet. So we're going to have to learn what you all think about the issues in both of those items.
And then one of the other questions we got is about the makeup and the composition of the BDAC. Are you in a position to answer questions on that? Like, you know, why there are different people from different, there's some government, some industry, and why the numbers on each side?
Actually, I'm not really in a position to answer that. We're really focusing today on the notices as opposed to the BDAC. There was an effort to try to get some degree of balance, and of course, no one's going to be entirely happy with any particular balance. If you are interested in learning more about it, I would say go to the FCC website and search for Broadband Deployment Advisory Committee, or BDAC, and you can find out what's been done so far. In terms of why it's been done, I'm not really in a position to address it, but we are trying to achieve balance, and we welcome comments in this proceeding about how we can get to the most balanced and fair outcome possible.
And then we have another question from Fairfax County, Virginia. The question is about whether the commission is going to require commenters who are saying that a particular community is, you know, a delay problem. Are we going to ask those commenters to say who the communities are that are the problematic areas?
Well, we're not going to require that, but I think I can say that the more specific information we get, the more we will know what to do with it. And if it's a vague suggestion that says somebody's being mean to me, it doesn't really give us much to go with. If somebody says X county in Y state is doing the following things, and we think it's inappropriate and contrary to the law, and then that community says, well, actually, it's permitted, that gives us a lot more to work with. So in real lawyer terms, I would say it doesn't go to the admissibility, it goes to the weight. In other words, you can say general things about people, and it may be it may not be very persuasive. So we would encourage folks to give us the best possible information you can. Also, rather than just telling us anecdotes, it's very useful to have more systematic data. We are very committed to using real data in making our decisions, and so this is an area where we'd like to have that to the extent possible.
We've got another question. There's kind of a little setup, so I'm trying to figure out. This one comes from Dover, Delaware, and we are.
Well, maybe I can try to address it. It's a very detailed question, and I'm going to apologize to the questioner because we can't really address a very specific individual problem. Although, as I said, if you describe it in the docket and you lay it out, that will give us a great opportunity to think about it in more detail. Off the top of my head, it'll be a little harder to do that. I think the questions are basically where a state Department of Transportation is looking into whether a particular new communications pole in the right-of-way, trying to evaluate how that affects a particular property owner. How is that consistent with the Communications Act, and how is it sort of just sensible to look into the impact on just a single property owner? This is a very interesting question, and honestly one that I haven't given much thought to because I haven't seen it before. And we would love to hear more about this. And I'd encourage people who are affected by these kinds of questions to describe it to us and explain it. And also state departments of transportation have been active, and public utility commissions. And so to the extent these disputes are coming up, if it's something that we can provide more clarity on, that is what we're here for. I think we all have the same interests, which is to be sure that everyone understands what's required so that we can make this process work for everyone. So please tell us more in the comment cycle, and we'll look into it.
And then we have another question also from Dover, Delaware. And the question is about whether the FCC will be providing any level of funding to support these unfunded mandates to the states.
Well, the FCC is not a funding organization. So with the exception of a program called Universal Service, which is really focused on providing support for people building out in unserved rural areas. Beyond the parameters of universal service, we don't go out there and provide funding to states to support unfunded mandates. I would suggest that that be directed to other agencies of the federal government. Not much more I can say about that.
And then now we have a question from the Wisconsin Historical Society, and they're asking, could the deemed granted remedy move a project forward while historic preservation review is ongoing, meaning additional work is required?
That's a good question, and it relates to the two different parts of this notice. Part of it is about the state and local review process, and the other part is about issues of historic preservation review and environmental review. And the short answer is that the deemed granted relates to state or local zoning decisions. So they're really two independent sets of decisions. So the remedy that I've been talking about when I talk about deemed granted has to do with a request to a state or local government. The historic preservation process is separate, so that wouldn't be part of the deemed granted that I've been talking about here.
We have a question from Montgomery County, Maryland, which is, in residential neighborhoods, the existing streetlights are only 14 feet tall. Would the FCC consider a 10-foot increase, a 71% increase, to be minor under Section 6409 rules?
I'm not really in a position right now to give you an opinion about what that rule does and does not require. I know that our rules do address it. And what I can do is, if you want to shoot me an email, I can try to get back to you with the answer to that question. But I guess I should say that the proceeding we're talking about here is a notice of proposed rulemaking, notice of inquiry. We are not proposing to go back and reopen the Spectrum Act or the Section 6409 rules. Those rules were just adopted a few years ago, and honestly, we're leaving them in place. We're focusing on everything that isn't covered by those rules.
Okay, then we also have another question from Montgomery County, Maryland, which is the FCC has exclusive authority to establish RF emission standards. The FCC opened proceeding ET 13-84 to review these in 2013. I'm going to try and paraphrase a little bit.
I guess the question here is whether the commission is going to try to complete the 2013 proceeding about RF emissions before it goes forward with issuing further preemption of local zoning in residential neighborhoods. And the answer to that question is we're looking at both of those proceedings, and I couldn't tell you that the timing of one is going to wait for the timing of the other. They're both important proceedings. We're looking at both of them, but the timing of one does not depend on the timing of the other. So RF emissions, human health, a very important priority. Deployment of broadband facilities, also an important priority, and we're looking at both of those questions.
We're going to pause for just a minute. We have some other questions questions coming through the printer right now. So just give us one moment while we get those off the printer.
Well, I have a question here that didn't just come off the printer, but I've seen it asked before, so I'll ask it and answer it. The question is really, why would the FCC, why would a federal agency go and take authority away from state or local governments, which are really in the best position to figure out whether this infrastructure is needed, whether consumers even need or want these services? Why would the federal government come in and basically tell the states or local governments who are closer to their constituents? And the short answer to that is, well, Congress said so. Congress does very clearly preserve the authority of state and local governments, but Congress also very clearly says, and this is in Section 332C7 of the Communications Act, that there are limits to how that authority can be exercised. And Congress has also made clear, and the federal government, and I should say most of the state and local governments, are making clear that these new services are services that consumers, citizens want, and to get those services out there, the people who build the infrastructure have to be able to do that. And so that's a priority for the whole country, and the FCC has been tasked with making sure that barriers to that kind of deployment are removed or reduced, and so we're going to carry out the mission that's been given to us.
Now we have another question from South Carolina, Mount Pleasant, South Carolina. The question is, are the Advisory Council on Historic Preservation and the NCSHPO involved in commenting on the NPRM/NOI? If so, what role are each of these organizations playing?
Sure. The Advisory Council on Historic Preservation is a sister federal agency which is responsible for historic preservation issues. The NCSHPO, I believe it's the National Council of, or National Conference of State Historical Preservation Officers, and both very important organizations looking at the historic preservation issues. So I can't tell you whether or not they're going to comment, but I would certainly encourage them to if they're listening in. And if you are a constituent of the NCSHPO, if you're a state historic preservation officer or office, your comments are very much welcome as well. And so I think those organizations are going to play an extremely important role. And on the historic preservation issues, we are going to be conferring with them and consulting with them in any decisions affecting that. And in fact, I believe that we had a separate conference call with the SHPOs just a few days ago. So we are definitely reaching out to them and working closely with them. Okay, we have another question coming in, but
So we have one more question coming in. This one is from the Bureau of Consumer Services and at the Pennsylvania PUC. The question is, can any changes resulting from this proceeding be identified as precedents to future products, services, and proceedings?
sure. This proceeding could very well, is intended to lead to a report and order. So a notice of proposed rulemaking is not precedent, but a report and order is precedent. And we're going to take the comments that we receive on these notices, and most likely the commission is going to vote to adopt an order. And yes, that order will be precedent for future products, services, and so on. So if I understand the question, I think the answer is yes. Here's a question about the federal, I believe this is about the Federal Highway Administration, if I'm getting it right, and whether the differences in policy between the FCC and the transportation agencies will be coordinated if there are different policies. Again, there are a lot of sister federal agencies that we consult with, and we are also welcoming comments from the state counterparts. And so please fire away, and we would love to see what you have to say. And to the extent that there are differences in policy that we haven't identified or that the other agencies haven't identified, identify them for us, and we will try to get that coordination to happen.
So we have one other question. This one is about why the FCC in this notice seems to strongly favor the interests of the wireless companies over the interests of local communities and citizens. Can you address that?
Sure, and I appreciate the question. The short answer is that we don't favor the interests of companies over the interests of citizens or consumers. I think the goal of the FCC, as well as the goal of the states and the local communities, the local governments, is to serve citizens. And so we're all really working towards the same end. The reason that there are proposals to expedite the process and perhaps reduce what we think of as regulatory impediments at the state and local level is because we've observed the process and there do seem to be some problems. And it's in everyone's interest to avoid having regulations get in the way of getting services out to the people and having facilities in place to make those services possible. So I don't think we're trying to favor one side over another, and to the extent that we could be striking a better balance, again, your comments will be very valuable, and we certainly do intend to read all of them. And so to the extent that there's a better balance that we ought to be striking, tell us so, and we will think about it. Here's a good question from Virginia. Are the new regulations proposed in this proceeding consistent with the Commission's goal in other proceedings of reducing the burden of federal regulation? I think our goal is to reduce the burden of regulation, period, whether it's federal, state, or local. And what we're doing here is, I think, aligning the interests of the federal and state and local levels of government and tribal to not do things that are unnecessary if they get in the way of bringing these services out to people and bringing these facilities out to people. So we really would like to reduce the burden of federal regulation and reduce the burden of state regulation and local regulation, and really let the marketplace do what it does very well, which is matching consumers' demands with the investments that the carriers and so on are putting in. So I do think that these are consistent.
I just want to take a minute to let you know, if you have questions and you didn't get them in time, or the cyberspace is taking a little bit long in getting your questions to us, the email box will be open continually. It's iga@fcc.gov. We'll work to get you responses to your questions as quickly as we can. If we didn't get to your question today, we will try and do that very quickly. And I'm trying to see if we have another question coming in. Then this question is, how does the chairman plan to continue the initiatives put in place by his predecessor, where the commission facilitated meetings and talks between stakeholders meant to resolve the issues by consensus of these groups?
Well, without really assessing the approaches of one administration or another, I would say that the public notice issued in December 2016, when the prior administration was leading the agency, and the notices that were issued in April under the current chairman are really quite consistent with each other. And so I don't see a lot of difference there. I think that meetings and talks between stakeholders are happening, and these advisory committee working groups are a great example of how that's happening. We do want to get issues addressed by these groups, and we also want to push forward everything that the FCC can do to promote our goal of facilitating broadband investment. So it's really not an area where I see a whole lot of difference. I think that there's actually a pretty bipartisan consensus that this is an important direction we should be taking.
Thank you, David. I think we have used up our allotted time for today for the webinar, and we appreciate your coming and giving the presentation and answering questions. And to the extent that we have not gotten to your questions out there, we will try and get back to you very soon. And
just to reiterate something that I think I've said about 20 times, please participate in this proceeding. File your comments, file your reply comments. The process for doing that is very simple. You can learn about it on our website, the ECFS proceeding, and of course you can talk to us. So these are open proceedings, and we really appreciate your input and look forward to reading your comments.
Thank you very much, everyone. Have a good afternoon.